Hello and welcome to episode 3 and lesson 3 of our Law of Tort series. Now, in our previous episode 2, you would recall that we treated the tort of assault, where we established that in order to be successful in an action of assault, one needs to establish all the elements of battery except the element of physical contact. One must prove the following. One must prove intentional interference. One must also prove the requisite state of mind of immediate or imminent physical contact. One must also prove that the plaintiff had reasonable apprehension, and it should also be established that there was a positive act by the defendant. In today's episode, we will deal with the tort of unlawful arrest. We are going to identify the elements of the tort of unlawful arrest and highlight the major principles you would need to explain these elements. This will also help us appreciate how they are applied accordingly. We are also going to look at how a private individual could arrest as compared to how a police officer could arrest. We'll look at the principles governing arrests by warrants as well. So to begin with, what is the tort of unlawful arrest? Everyone is entitled to freedom from physical restraint and is protected against unlawful interference of his freedom of movement and personal liberty. The tort of unlawful arrest, therefore, secures these freedoms and rights. The law on unlawful arrest could be founded in 3 sources of law, namely at common law, the Criminal Procedure Act 1960 Act 30, as amended by NRCD 235, and Articles 14 and 21 of the Constitution of Ghana 1992. Now, at common law, the position on unlawful arrest as follows. This was laid down in Lechinsky versus Christie by Viscount Simon L.J. 1. If a policeman arrests without warrant upon reasonable suspicion of felony or of other crimes of assault, which does not require a warrant, he must, in ordinary circumstances, inform the person arrested of the true ground of arrest. He is not entitled to keep the reason to himself or to give a reason which is not the true reason. He is not entitled to keep the reason to himself or to give a reason which is not the true reason. In other words, a citizen is entitled to know what charge or on what suspicion he is being seized. 2. If the citizen is not so informed but is nevertheless seized, the policeman, apart from certain exceptions, is liable for false imprisonment. 3. The requirement that the person arrested should be informed of the reason why he is seized naturally does not exist if the circumstances are such that he must know the general nature of the alleged offense for which he is detained. 4. The requirement that he should be so informed does not mean that technical or precise language need be used. The matter is a matter of substance and turns on the elementary proposition that, in this country, a person is prima facie entitled to his freedom and is only required to submit to restraints on his freedom if he knows, in substance, the reason why he has claimed that this restraint should be imposed. 5. The person arrested cannot complain that he has not been supplied with the above information as and when he should be, if he himself produces a situation which makes it practically impossible for him. Example, where he occasions an immediate counterattack, or where that particular person attempts running away or actually runs away. He further stressed that there may well be other exceptions to the general rule in addition to the 5 principles indicated above. And the above propositions are not intended to constitute a formal or complete code, but to indicate the general principles of our law on a very important matter. These principles equally apply to a private person who arrests on suspicion. If a policeman who entertained a reasonable suspicion that X has committed a felony were at liberty to arrest him and march him off to a police station without giving any explanation of why he was doing this, the prima facie right of personal liberty would be gravely infringed. No one, I think, would approve a situation in which, when the person arrested asked for the reason, the policeman replied, "That has nothing to do with you. Come along with me." On the reasonability of the suspicion and its consequences on a private person arresting as against a police officer arresting, Sir Rufus Isaacs, in the case of Walter v. W. H. Smith and Sons, clearly explained the principle that an arrest by a private person is lawful only where the offense for which the person is being arrested has in fact been committed, and the person has reasonable cause to believe that the person he is arresting is the one who is committing that felony. However, the police are on reasonable suspicion to prove that an offense has actually been committed, but is not necessarily to be the person arrested, unlike the private person. Again, Lord Diplock LJ in Darlinson v. Caffrey re-emphasized the principle by stating that the rule that a person who arrests, detains, or prosecutes a suspected felon commits no actionable wrong if he acts honestly and reasonably applies alike to private persons and to police officers. But what is reasonable conduct in the circumstances may differ according to whether the arrestor is a private person or a police officer. A private person can only arrest if he reasonably believes that an offense has, in fact, been committed, whereas the policeman is to arrest if he reasonably believes that an offense has been committed. The onus probandi, or burden of proof, lies on the arrestor. In all others, the rule of reasonableness applies. He further explains that since arrest involves trespass to the person, and any trespass to the person is prima facie tortious, the onus lies on the arrestor to justify the trespass by establishing reasonable and probable cause for the trespass. The trespass by an arrestor continues so long as he retains custody of the arrested person, and he must justify the continuance of his custody by showing that it was reasonable. What is reasonable conduct on the part of a police officer in this respect may not be the same as what would be reasonable conduct on the part of a private arrester. Lord Denning, on the same case, in explaining what would constitute reasonable and probable cause in such a matter, used the objective test, which is that whether a reasonable man, assumed to know the law and possessed of the information which in fact was possessed by the arrester, would believe that there was reasonable and probable cause in arresting the person. Let's look at some decisions by the Ghanaian courts in support of the 5 requirements at common law. In Asante v. Republic, Antechi J. established that a lawful arrest by a police officer is done by first showing of his identity, second, by telling the person that he is being arrested, third, the reasons for so arresting, and fourth, by touching him. Take note that this principle in Antechi J goes to affirm all the above requirements, but particularly the first requirement in Christie v. Lechinski. And Apalu J in Tando v. Edu reaffirmed this requirement. Also, Section 7 of Act 30 affirmed the third and fifth principle in Christie v. Lechinski in the following words: Unless the arrestee is caught in flagrante delicto, the arrester shall inform the arrestee of the cause of arrest. Where he is acting under a warrant, notify the arrestee of the substance of the warrant and show it to him if he so desires. See the case of Yao versus Kobna, which in particular affirmed the fifth principle. Also, Barnett AG, CJ in Asumeni Bugembi versus Attorney General, affirmed the fifth principle by stating that the duty to inform a person of the reasons for his arrest is relieved if the person, under the circumstances, knew the reason why he is being arrested, or creates a situation that makes it impossible for the one arresting to inform him of the reason. The person arrested cannot complain that he has not been supplied with the above information as and when he should be, if he himself produces a situation which makes it practically impossible to inform him. An example, by immediate counterattack or by running away. Nicole J. in Mahajna versus Secretary of State for Home Department supported the fourth requirement by saying a person arrested must be given sufficient information in a language he understands so as to know the reason for his being arrested. On affirmation of the fourth requirement in the case of Christie versus Lechesky, Wolf LJ in Abase versus Commissioner of Police held that a person arresting need not specify a particular crime for which he is arresting or use any technical language. It is sufficient if the person being arrested understands the reason why he is being arrested. However, if a person only goes to make a complaint to the police, will that person be liable for unlawful arrest if the police arrest the person the complaint goes against? In the case of Nkrumah versus Foley, Chumesi J. answered this question in the negative by holding that for a person to be liable for an arrest effected by the police, he must have actually authorized and directed the police officer to effect the arrest. A person incurs no liability if he only makes a complaint and the police officer acts on his own discretion. The fact that a person is acquitted following an arrest does not necessarily render the arrest unlawful. Let's look at some statutory provisions under Act 30 and the Constitution on this particular area of torts. The general provisions in Act 30 relating to arrests are that 1. Under Section 3, a person being arrested must be touched. Section 4 also states that the occupant of a premises must permit the arrestor to perform his duties where the arrestor is holding an arrest warrant. Section 5 also states that the person conducting the arrest may likewise break out to liberate himself where he is being attacked. Section 6 says the dignity of the person being arrested must be respected when arresting. Section 7 says unless the arrestee is caught in flagrante delicto or in sight physically, the arrestor shall inform the arrestee the cause of the arrest where he is acting under a warrant, notify the arrestee of the substance of the warrant and show it to him if he so desires. Section 8 says the arrestee is to be decently searched and all things found on him placed in safe custody. Section 9 continues as the arrestee must take all the items on him dispatched to a police station or any other place where the arrestee can be taken and to be told without delay of the complaint against him. The arrestee is to be given reasonable facilities for obtaining legal advice, taking steps to furnish bail, and making arrangements for his defense or release. Section 14 states any private person arresting without warrant shall without unnecessary delay hand the arrestee over to a police officer or a police station or take him to the nearest police station. Section 15 says a person taken into custody without warrant shall be released not later than 48 hours unless is earlier brought before a court. He can be bonded with or without sureties to appear before such court or police station or place at such time is situated in the bond. We must note that as indicated in the beginning of the episode, you must read Article 14 of the Constitution and the case of Martin Kpebu versus Attorney General, the valedictory judgment by Sophia Kufu CJ as she then was, the judgment on the 48-hour rule in Article 14. Let's move on to arrest without warrant in Ghana. How can a police officer arrest without a warrant? Section 10 of Act 30 clarifies that a police officer may arrest without warrant a person who A. commits an offense in the presence of the police officer, B. arrests a police officer in the execution of that police officer's duty, C. has escaped or attempted to escape from lawful custody, D. possessed an implement adapted or intended for use to unlawfully enter a building and does not give a reasonable excuse for the possession of the implement, or E. possesses a thing which may reasonably be suspected to be stolen property. A police officer may arrest without warrant a person whom the police officer suspects on reasonable grounds of A. having committed an offense, or B. having been about to commit an offense in order to prevent the commission of the offense, C. of being about to commit an offense where the police officer finds that person in any highway, yard, building, or other place during the night, D. of being a person for whom a warrant of arrest has been issued by a court, E. of being a deserter from the armed forces, or of having been concerned with an act committed outside the Republic which, if committed in the Republic, would have been punishable as an offense and for which that person is, under an enactment, liable to be arrested and detained in the Republic. Let's look at how a private person arrest can happen without a warrant. This corresponds to Section 12 of Act 30. Under this provision, 1. A private person may arrest without warrant another person if that person in the presence of that private person commits A. an offense involving the use of force or violence, B. an offense by which bodily harm is caused to another person, C. an offense in the nature of stealing or fraud, D. an offense involving injury to public property, or E. an offense involving injury or property owned by or in the lawful care or custody of that person. 2. A private person may arrest without warrant a person whom that private person reasonably suspects of having committed any of the 5 offenses mentioned above, where an offense of that nature has been committed. In the case of Lewis and Co. Limited versus Timms, Lord Porter held as follows: where a private person arrests, his duty is to take the arrested person to the police station or judge as soon as he reasonably can and not immediately. Also, remember that we said early on by Justice Isaacs, Diplock, LJ, and Lord Denning on the reasonable suspicion. In summary, the law allows a private individual to arrest another on suspicion. However, 3 conditions must be satisfied, otherwise the arrest will be deemed unlawful. And these are, firstly, that any of the 5 offenses stated is in fact found to have been committed. Second, that a private person establishes the commission of any of these 5 offenses on reasonable suspicion. And third, that the person who actually committed the offense established is the person actually arrested by the private person. In conclusion, on arrest with a warrant, which is issued by a judge, you may read Section 71 to 81 of Act 30 to see the law on that effect. This is the end of our third episode. We hope that you learned and you will join us for our next episode, which will be on false imprisonment. Don't forget to like, comment, share, and spread the word on what is happening on this channel. Thank you.